Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hi, and welcome to the latest in our Smarter Lawcast podcast series, where we're going to discuss the impact of AI on legal professional privilege. My name is Katie Moore, and I'm a partner in the projects group. It's no surprise to anyone at all that AI is transforming the way we work. The speed and pace of change is huge, but one area that hasn't been discussed a lot and probably should be is the impact of AI on legal professional privilege. To unpack this issue, I'm joined by my colleague, Lauren. Lauren, would you like to introduce yourself?
Hi, Katie. Yes. So my name's Lauren Saparovich, and I'm a special counsel in the dispute resolution team here at Hall and Wilcox, and I'm very pleased to speak with Katie about this ever-changing topic.
I think probably the best place to start is the various issues that have arisen in AI just in the last 2 months since the beginning of the year. Lauren, I know that you've come across a few reports that have come out recently. Would you like to take us through those?
Yes. So as we well know, AI can assist lawyers and everyone in many ways, but in so doing, if documents are uploaded, or you can inadvertently waive legal professional privilege, and that's caused a lot of concern. And those are some of the discussion points that have been canvassed by recent reports and documentation that's seen a lot of change in this space. Very recently, only a month ago today, actually, the Victorian Law Reform Commission tabled a artificial intelligence in Victoria's courts and tribunals report. And this report marks the first inquiry by an Australian law reform body into the use of AI in courts and tribunals. It contains recommendations to ensure the safe use of AI in Victorian courts and tribunals, and has 8 overarching guidelines or principles to guide the safe use of AI and maintain public trust. And one of the points canvassed was relating to the use of AI and encouraging lawyers not to upload confidential information into open AI platforms. Now, obviously, it's going to be very interesting to see the extent to which the various recommendations, of which there are many, as it's a very significant report, are actually adopted in Victoria and even perhaps more broadly, because as it stands, a lot of the courts and tribunals everywhere around Australia and internationally have a bespoke position in their own respective guidelines or regulations that would be really benefited by uniformity. And that's one of the things that's recommended in this report.
I think one of the issues that we have about AI as a whole is that there isn't a lot of regulation on it. It's a particularly unregulated industry. It's evolving, it's changing, and the law, as we know, is very slow, and it seems to be a long, long way behind the technology. And it's interesting to see how all the different courts grapple with it, given that there is no regulation, because there's no one really taking the lead, even in the international sense. There doesn't appear to be anyone taking the lead, which is something that we'd like to talk about in a later podcast about how this is being dealt with internationally. I think it's also very important from a legal perspective, particularly in the context of legal professional privilege, to look at the difference between closed AI and open AI. And I know that you mentioned that the Commission did look at the difference between, or specifically said that you shouldn't be using OpenAI. OpenAI, it's not just the name of an AI product, it actually means that it is open and open to the public. It is the whole entire internet. So whatever you put into that artificial intelligence program is spread across the whole internet, as opposed to closed AI like the one here at Hall and Wilcox. Of course, we only use it if our clients allow us to, which is called Harvey, and it's closed AI specifically for use by lawyers. And it is used, I think it started in the US, and it's used all around the world by lawyers in common law jurisdictions.
So, yeah, exactly. So the Law Reform Commission very helpfully helped define some of those terms and encouraged that perhaps those defined terms, if you will, would come across and be adopted by other Victorian courts and tribunals, such that there could be a consistent definition as to what's closed AI versus public or open AI. And one of the points, as you've canvassed with respect to closed AI, is the confidential settings that protect that information from being made publicly available or that are used to train the AI tool. And that confidentiality and the specificity around how the inputs are dealt with is really key between what's closed and what's open or public or open.
So read the terms and conditions of the AI that you're using very carefully.
Yes, exactly.
Which is what we should probably be doing anyway. It's not just a matter of legal professional privilege. It's also about, as lawyers, we're required to maintain the confidentiality of our clients' information.
Yes, it comes into our obligations generally and our adherence to various conduct rules to be able to do such things.
For those of you who don't remember, but you probably do, Lauren, what is legal professional privilege?
So, of course, legal professional privilege protects confidential communications and documents between solicitor and client made for the dominant purpose of providing legal advice or for use in current or anticipated litigation. For example, practically, it might be a prospect's advice as to the merits of your client's case, or expert evidence required to determine the quantum of, say, an offer or a Calder bank, or even something as simple as email advice about how a client should protect itself optically in the public eye in instances of defamation or IP, or even a lot of the work that we do, Katie, with respect to public law. This inherent fundamental protection, legal protection, allows a person to resist demands from an opponent or from the court to disclose information or to produce documents which would reveal communications between themselves and their lawyer, where those communications were made for the dominant purpose of giving or obtaining legal advice or services. And so now, where does that fit in for the use of OpenAI? You're nodding your head.
Yeah, I am nodding my head, and this is a podcast, not a video.
Yes, exactly.
Yeah, so you can waive legal professional privilege, and you waive legal professional privilege by making it public. So the issue arises when people take advices that they've been given and put them through an open AI, and then that is then disseminated over the internet, and there's a potential that you've waived the legal professional privilege, so that if you end up in litigation and the other side wants to see a copy of it, and we say, oh no, we're asserting legal professional privilege on behalf of our client, because it's the client's privilege, not our privilege, and the client's already put it through OpenAI and disseminated it to the world, there's a very strong argument that information is no longer confidential, and therefore the privilege has been waived.
Exactly. And that feeds into exactly why we're here talking about this, Katie, because this is an instance you encountered, wasn't it, in practice?
Yeah, it is an instance I encountered when I had sent an advice to a client, and they said to me, oh, thanks for the advice. I ran it through ChatGPT so that they could summarize it and see if you'd missed anything. And I was like, what? So first of all, what ChatGPT came back with wasn't great. So that made me feel slightly better that you still need lawyers to provide you with legal advice. But it also meant that they had potentially waived that advice that had been given to them. And it's not just about advice either. It's also about if you send a document, the first draft of a document, with thought bubbles in that document. So I often, when I'm doing the first draft of a document, will say, do you need this? Should we think about this? What implication does X, Y, and Z have? Which is literally a note from me as a lawyer to my client to get advice from them. And they have been known to put those through an open AI system. Once again, that disseminates it out into the world, not just the drafting, but also
the strategy.
Conversation, the strategy. And I know that the Law Reform Commission has commented on that. Do you want to talk about that, Lauren?
Yes, so they found a couple of examples in the Commission report that have shown ways in which that's happened in a practical sense. For example, the Office of the Victorian Information Commissioner was a stakeholder that the Law Reform Commission spoke to, because they went out and spoke to a whole slew of different commissioners and different individuals and lawyers and barristers to be able to collate this report and get feedback as to their conclusions. And with respect to the Office of Victorian Information Commissioner, they found that a child protection worker had used ChatGPT to draft a report for the Children's Court. Now, this obviously was a serious breach of information privacy because it involved putting personal, but also very personal and sensitive information into ChatGPT. So it's eroding public trust, it's eroding privilege, it's eroding confidentiality.
Assuming it's a privacy breach as well.
Yes, privacy, personal, and very sensitive. If you're thinking about it from a children's court perspective, even from first principles, these are people who need to be protected, obviously, and the implications are huge. And yes, the Commission's report unpacked, strongly recommended that the extent to which any sort of disclosure could affect the trust in the legal system and the transparency of a legal system. And they found that to be paramount with maintaining the use and merging the use of AI into the court system. And that was seconded by many stakeholders, the importance of open and transparent use of AI in the courts.
I think it's something that we do need to think about and grapple with because AI is everywhere. And I know at Hall and Wilcox we have a very streamlined AI policy. But prior to us having our AI policy and introducing Harvey, you would see, not necessarily at Hall and Wilcox, but I know that particularly junior lawyers who have grown up using AI at university, not thinking about it, think nothing of putting something through ChatGPT or any AI because that's what they're used to doing. That's how they've collected information. And the younger you are, the more likely you are to have had access to that during your learning phases, and you just think it's a normal part of your life. So it's something that is actually really important that we really need to think about. And as the Law Reform Commissioners, we're so far behind the 8 ball when it comes to thinking about how it's going to impact our lives.
Well, this raises a couple of, I think, very interesting practical questions that haven't been answered yet because really it's too fledgling, and because we're only just having things like this report and things like the Victorian government only just released, beginning of last month, the AI-driven business-ready AI mission statement by the Victorian government. Like, this is only just happening as we speak and in real time, which is very exciting, but it's meaning really that people who are used to using open AI or public AI are using it in an unregulated sphere, and they're not growing up in inverted commas, if you will, growing up in the legal sense with the constriction or the conduct rules perhaps denoting the ways in which they are supposed to use that. And it's quite interesting if you think of it from the perspective of the way that perhaps more senior lawyers would use Google. Now, you would just Google a question perhaps as a bit of a cheat sheet, almost just to sense check something. But I think the difference there is that with Google, I know at least myself, I wouldn't put in sensitive information into Google. I would ask quite a general question. For example, in the purposes of this podcast, you'd say, what is legal professional privilege? You wouldn't say, can client A do something with respect to... The difference with something like open or public AI is often in the examples we're seeing and the example you've spoken to, Katie, and specifically with respect to the Children's Court example I mentioned earlier, that's the ramifications of putting that sort of information into a public system is very different to Googling a general query. So we're in a very different landscape here than what we're used to, and it's an unregulated landscape.
Yes, I think Google was quite unregulated anyway.
Yes.
And AI is, and also the people that own the AI platforms are pretty keen not to be regulated.
Exactly.
Which makes it even more difficult. And I do know that when, not regulation, but I know that a practice note came out from the New South Wales Supreme Court last year about the use of AI in court documents. And it was just a guidance only. And it was, if you want, we think you should note when AI has been used to produce court documents. I don't know the exact numbers, but I know that beforehand people were noting that they had used AI. Apparently, since the practice notes come out, not one single person has noted that they've used AI because they said you only have to do it if you want to. So that shows you that we're in this landscape where people just don't know how to respond. And we've got this technology that can be great, but we need to harness it correctly.
Well, exactly. And this is the point that you made with respect to New South Wales is my understanding more broadly around Australia, where there's a general encouragement to be open, and no pun intended, to be open with your use or reference to AI, but there's no requirement for disclosure. And that actually is something that the Law Reform Commission does address and recommends that perhaps there be a requirement for disclosure in certain aspects, with use of it in certain ways, for example, with respect to expert evidence and the like. But that's quite different to the position that we see sometimes around the world. And that might be something we speak to in a subsequent podcast, Katie. But we see some of our Commonwealth friends and friends even further abroad that have actually been more prescriptive in the requirement for disclosure of the use of AI. So I wonder whether we're heading in that direction.
I think we probably are. And I know that you and I delved into judicial consideration of the waiver of legal professional privilege by the use of OpenAI. And it's an emerging part of the law, you would have to say. And the jurisdiction that has the most definitive comments on it is, in fact, the family court, the federal and family court. And I think, and I'm saying this without any particular having looked into the background of it, but my thoughts are that a lot of people in the family court are self-represented, and as a self-represented litigant, you would use AI a lot more. And I know that there was a New Zealand High Court case which did involve a self-represented litigant in family court using AI, and the courts have said that it haven't been definitive, but they said it tends to waive legal professional privilege when you're putting information of that type through OpenAI.
Yes, I think, yeah, exactly. I think in the family court is where we're seeing quite a bit of it, noting that there hasn't been an authoritative ruling in Australian courts yet. So it's definitely a space that will be investigated, I'm sure, in the future. But I think where we've landed with some recent family court decisions is that it's been dealt with saying that may waive privilege or may fall foul of the requirements that things be treated as commercial in confidence. So we've got that disclaimer still there. But then the family court appears to have also emphasised that people should use extreme caution. Practitioners should use extreme caution when uploading and using AI. So it's ripe for investigation and regulation, hence why the Law Reforms Commission has come in and made so many recommendations.
Yes, yeah. There's been a recent decision in the US, hasn't there, regarding how closed a closed AI platform is, and that it was.
Yes. Yeah, there's been a very interesting decision in the US, only in February actually. It's the United States and HEPNA, where the Southern District of New York ruled that documents that a defendant generated using a publicly available AI platform, so there we are, we're back in the public AI use again, was not protected by privilege. That instance was a man named Bradley Hepner was charged with fraud arising from his alleged misconduct as an executive of some corporate entities, and after receiving a grand jury subpoena and learning he was target of a federal investigation, he, of his own volition, used the AI platform Claude, the open AI platform Claude, to generate approximately 31 documents that contained legal and factual queries related to the investigation, which included reports that outlined defence strategy and what he might argue with respect to the facts and the law. So my understanding is that he created these to sort of quote unquote help his lawyers and assist them in that regard. And they were seized by FBI agents when they raided his home. And which is
similar to the client of mine that ran the advice through the AI to come up with some questions about further questions. Yeah.
Exactly. And that was his counsel asserted that those materials were privileged because they were created by the founder to help analyse his own legal position and also to assist his lawyers. But it was actually ruled that the Claude generated material was not produced by either attorney or client, and such must be produced to the government in this instance. And some of the deficiencies in his claim for privilege included exactly like what you've canvassed, that the communications weren't confidential and that he did not communicate with his counsel, had not directed him to use Claude. He hadn't communicated. It wasn't in the instance that you referenced. You didn't ask your client to run it through ChatGPT. And it's quite interesting if we think about it in terms of the confidentiality, because I wonder whether, if anything were ever so slightly different, if his lawyer had have asked him to do it, if it had have been a closed system, would that decision have been different? Would it be that it was found that privilege was maintained over that?
Well,
So it's an ever-changing space.
It's interesting too, because they've said that the platform was not an attorney, which was one of the reasons why they didn't have, they call it attorney-client privilege over there, which is the same thing. And the platform's never going to be an attorney. So
No.
that's an interesting question as to whether it being closed would have changed. I guess if it was closed, you definitely wouldn't have, it would still be confidential, but it still wouldn't be an attorney.
Exactly. But then that feeds into one of the main points that we have by way of suggestions for people if they are using AI, is that it is worth checking the confidentiality of the inputs. And then we go back to checking the terms and conditions, because beware of what's happened with Hefner, where it specifically said in that instance that the inputs weren't confidential. So regardless of the attorney point, which is obviously a key point here, as first principles, it wasn't a
there was no confidentiality, so therefore it's gone.
Yes.
So what are some practical ways that lawyers can think about using AI safely before uploading anything? I think the first thing that we need to think about is the terms and conditions of the AI that you're using.
Exactly.
Is it a closed and therefore confidential system? I think that's the first point, because legal professional privilege attaches to confidential.
Yes, exactly. And also, who's having access to those, to that platform and to any of your inputs? Is that something where the company, the owner of ChatGPT or the company running those entities, is that something that they can run tests or they can do trainings over or anything, and your documentation, your confidential information is used as fodder for that? Because obviously that's leading to waiver.
The first thing that you should do before you use, this is for law firms, before you use AI at all, is, are you allowed to use AI under the terms of your engagement agreement? That's obviously your clients need to know that we're using these tools. So that would be the first thing that you would discover. And I know that all of our government clients at this point in time say that we can't use AI, so it's not used at all, even if it is a closed system.
Once we pass that threshold, though, then, and if we can, there are certain things to still keep in mind.
And in the system that you use, if it's a closed system, is it disseminated to other people within that closed system?
Exactly.
Or is it just to the user of the license at that point in time?
Exactly. Is it accessible or used? Is it even used for any other purpose? Is it used for other people, but for other purposes? I go back to the training point. It very well may not be disseminated more broadly in a ChatGPT sort of way, but is it used internally for their training systems at the other end? Because that still isn't closed to the degree that we as practitioners would feel comfortable maintaining confidentiality with.
No, you'd want it to be specific to the questions that you are asking at that point in time, and then it forgets it. So it's not sucking up that information and keeping it and using it in the rest of the system.
Exactly. And obviously, then we also, coming back to your first point with respect to whether it's even allowed to be used, if it is that it's allowed to be used from a sense of, is the client that you're proposing to use AI with respect to, is it part of there's no specification in the engagement agreement or otherwise that sort of discourages you from using it? It's still something that you need to obviously obtain informed consent of from the client, and it may be that we're in a world where that requires, practically as practitioners, a discussion with clients and really talking them through and making them as comfortable as possible as to how closed a platform is and what parameters we put in place at Hall & Wilcox and as practitioners at large, as how we're looking at very closed and very confidential usage and how those inputs aren't being spread further afield. So it's also about ensuring that we're not doing the wrong thing, but it's also about the comfort and the transparency. Again, we're going back to transparency and trust in the legal system.
Clearly a topic that we could talk about for another couple of hours, particularly given it's ever changing. And in our next episode, we'll do a deep dive in more detail into the Australian courts and the regulators are dealing with this new and emerging technology that is becoming part of our everyday life. And we've got more topics on the landscape where we will talk to some of our colleagues around the world in common law jurisdictions and how they're grappling with this issue.
Yes, because there's a lot of change and shift and differing opinion across places from the Caribbean to what we've seen in the US. And yeah, it's very interesting. And that's actually canvassed by the Law Reform Commission as well to a degree. So you see that cross section, and it's a very interesting space, and there's a lot to talk about.
I'd like to thank everyone for listening today. As always, please be in touch with either Lauren or myself if you have any questions. You can find our details on the website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe to our podcast wherever you get your podcasts.
Thank you very much. Thanks, Katie. Thank you all.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.